everybody. It's Chris B once again with CSB Security Inc. and yet another informative video. Today, we're going to talk about the top 10 things you should know moving into the Cannabis Act from either the ACMPR or as a new applicant. Before I move forward, there's always a disclaimer that I like to give. What I'm about to tell you is actually based on hard fact. It's based on the Cannabis Act, but some of my answers and some of my opinions are my own. It's based on 5 years experience dealing with Health Canada under the ACMPR, over 300 applications, 100 site visits, 50 attestations, the whole 9 yards. The point is that any opinions that I may have during this video are mine alone, and your experiences and opinions may vary. So, as I mentioned before, I'm going to give you the top 10 things you should be aware of in the new Cannabis Act that you may not have been aware of that either are ported over from the ACMPR or are brand new as a lessons learned from Health Canada over the past 5 years. Number 1 on the list, and by the way, these are in no particular order. These are just the top 10 things you should be aware of. Number 1 is an Artpic on site. Under the ACMPR, Health Canada requires that anybody that is non-security cleared and they are working with cannabis has to be managed and escorted and watched over by an Artpic. What that basically means is that anytime you have any worker that's not security cleared, they must have an Artpic watching over what they do. Sometimes in a massive facility, that could mean 8 Artpics, 8 security cleared staff to manage 20 non-security cleared staff. That's a large complement of security cleared staff, whether it be in their trim rooms, dry rooms, harvesting, in their clones, whatever, in their mothers, in their flower rooms, whatever it is. You need to have an Artpic escort cannabis at all times, and especially when there are non-security cleared staff within a room. Under the Cannabis Act, Health Canada just mentions that an Artpic has to be on site. So what we take that to mean is that you no longer need to supervise cannabis inside each cannabis present room. You no longer need to worry about escorting cannabis down cannabis present hallways. You just need to have an Artpic on site to manage the entire site as a person who has a higher authority and clearance level than everybody else. So a security cleared Artpic is needed in the Cannabis Act. Not for every single room, just needs to be on site. That's a pretty big change from the ACMPR, and potentially new clients going forward that are applying under the Cannabis Act that have not applied under the ACMPR only have to have 1 security cleared staff member versus some people under the ACMPR that had 5 or 6 to manage the same footprint. So, big change. You need to be aware of it. Still need to have security cleared staff, 1 Artpic as a minimum. You no longer need to have Artpics in every single room when cultivating or, of course, when there's non-security cleared staff in contact with cannabis. Number 2 on our list is that Health Canada stated you now must nominate a master grower. Now, of course, under the ACMPR, most applicants nominated a master grower anyways. Whether it was an Artpic, whether it was a person that was hired that's non-security cleared, whatever the case may be, they had somebody that knew a lot about growing, a lot about how they specifically wanted to grow, and they may not have given them the title of master grower, but that was what their representation was, and of course that's what their duties were. Under the Cannabis Act, Health Canada has come right out and said you need to nominate a master grower. That's a big thing. Make sure that's in your application. Nominate the master grower. If they're Artpic status, that's great. If they're security cleared, that's even better. If they're master growers, you need to tell Health Canada who they are and their duties and responsibilities. Number 3 on the list is you must nominate a QA, a quality assurance person. Under the ACMPR, they speak to somebody that's in charge of QA, somebody that helps to make sure you're GPP compliant, that can write SOPs, somebody that makes sure that there's quality assurance for all the product that's leaving your facility. The point is you can actually hire somebody off-site, somebody to come in part-time to make sure things are going well. It could be an Artpic that it was a blended role, whatever the case may be. But you didn't have to actually spell it out. You didn't have to actually say, we have a QA person and it is this person. Under the ACMPR, you could say, we will have a QA person. Or we will do some testing here and there. Or we'll have somebody come in part-time. Under the Cannabis Act, Health Canada said you must nominate a QA person. That is another big change. So now not only do you need to nominate a master grower, you need to nominate a QA person. Can they be blended roles? As of right now, the answer is yes. You could have blended roles. Would you want to? That's a different story. The point is, QA, you need to nominate the person that's involved in QA, their roles and responsibilities, what they're going to be tasked with, and you're most likely going to task them with creating all your SOPs. Number 4 on the list is the Director of Security. That's a new one. So under the ACMPR, Health Canada never mentioned that you have to have somebody that's a director of security. They didn't even mention that you needed to have anybody that knows security. Under the Cannabis Act, they've actually specifically mentioned you need to nominate a director of security. You need to make sure they have the roles and responsibilities clearly laid out in your application. That is a pretty big thing. I know for a fact it could be a blended role. You could have an Artpic that's also head of security. The point being is you need to nominate a director of security. Didn't need it under the ACMPR. You definitely need it under the Cannabis Act. Number 5 is you need to still identify your secured storage areas, or areas where cannabis is going to be stored overnight. So under the ACMPR, you need to store cannabis either in a vault based on the directive or in a secured storage room based on the 56 exemption. I talk about the 56 exemption in another video. It is ported over to the Cannabis Act. There's no mention of it in the Cannabis Act, but some of the concepts and the realities of the 56 exemption have been automatically ported into the Cannabis Act. Point being, you still need to nominate and still need to let Health Canada know where you're going to be storing cannabis overnight. Either on your drawings, it should be a secured storage room. Maybe you're going for a vault. Maybe it's because it's part of being GMP compliant, which is something I talk about in another video. Maybe you just want to protect the assets of your facility, i.e. any dried product, whatever the case may be. Cannabis has to still be stored overnight in a more secured room, either a vault or a secured storage room. You still need access control. You still need intrusion detection. You still need video surveillance. You still need to log to and from that secured storage room. That's a big one. Don't fall trap to the new Cannabis Act. It clearly states you have to log access to and from any storage areas, and they're referring to cannabis storage. The point being is you still need to nominate a cannabis storage area that's where cannabis is going to be stored overnight, and you still need to protect it and articulate to Health Canada how you're protecting that space. Number 6, perhaps the most important one that's come from the Cannabis Act, which is a big change from the ACMPR. Under the ACMPR, you needed to retain video images from your video surveillance system for 2 years. That was huge. That took the industry by storm, actually. It caused a lot of systems to be upwards of 5, 6, 7, 8, sometimes 10 petabytes of storage. We're talking server farms. We're talking huge amounts of storage and, of course, huge amounts of money. Health Canada, under the Cannabis Act, has stated that you no longer need to retain images for 2 years. It's now 1 year. Along with the 56 exemption, which allowed you to remove cameras in cultivation spaces, again, I talk about the 56 exemption in another video, go ahead and watch it, you now reduce the requirements for storage, not only by 1 year, but also the cameras that need to record for 1 year, potentially by 25%. Huge cost savings across the board. We applaud Health Canada for making that decision. 2 years was a little overkill. 1 year, still maybe overkill to some people, but it's a hell of a lot better than 2. Unfortunately, some of the clients that maybe didn't take the recommendations from consultants to say, you don't need 2 years of storage straight out the gate for your application to get a license. You just need to have 2 years of storage eventually, and didn't go for 6 months storage to begin with, were hit with a huge bill, and now they've got extra storage that they may not need. For those that did 6 months of storage and with the intent of adding more storage hard drives as they go along to meet the 2 years, are now enjoying a 1 year savings of storage. Point being, 2 years to 1 year, huge cost savings. Under the Cannabis Act, it's 1 year. Under the ACMPR, it's still 2. Moving on our list, the removal of motion detectors. Now, we did talk about the 56 exemption in another video, and I mentioned it now 3 times, so I'll stop mentioning it. Point being is that under the Cannabis Act, you no longer need motion detectors inside of your cultivation rooms. That's a huge thing. Motion detectors were very difficult in those spaces. They had a hard time operating in the environment. You can remove motion detectors inside those rooms, not only as a cost savings for the installation itself, but also less nuisance alarms in those areas. Now, be mindful, again, perimeter walls, you got to be careful of that. You may still need the motion detector inside the cultivation rooms if your perimeter walls of your facility are actually the walls to your cultivation rooms. Next on the list is the removal of cameras. I already mentioned that a little bit before, but now definitely under the Cannabis Act, again, taking the 56 exemption into play, you can remove cameras from your cultivation rooms as long as you've got a camera that captures images of people coming and going that space. Again, it goes along with the 2 years of storage down to 1 year. Removing cameras in those spaces was ideal. You may want a business decision camera in there. It does not need to record for 1 year. It can record for 15 days, 30 days, or not at all. The point is, you need to know that you can reduce the camera count and the motion detectors inside your facility based on the Cannabis Act, which is taken in consideration the 56 exemption. Number 9 on our list, and this is a pretty big one, Health Canada has come out with different types of licenses. So obviously under the ACMPR, we knew about LDs, we knew about LPs, licensed distributors, licensed producers, but you had to tell Health Canada in your application what exactly you were going for. So you had to say, okay, well, I would like to go for an LP license. I would like to do extractions. I would like to do only extractions. I would like to do some research and development. Whatever it was, you were limited by the options that you had, and that you had to include everything with your license. And you were granted a license based on what you told Health Canada was going to be part of your application. Moving forward, under the Cannabis Act, Health Canada has come out with a number of different licenses. I talk about that in another video. Go ahead and watch it. The point being, there's now micro grows. There's now license to cultivate, license to only do some growing, some distribution. There's a lot of different licenses out there now that you need to know about, but that's a huge change from the ACMPR because now Health Canada says you have to apply for each type of license and be granted each type of license so that you can move forward under the Cannabis Act. ACMPR, LDLP. Cannabis Act, some 10 different subcategories and license levels that you need to get. Lastly on our list, Health Canada has now come out and said, okay, under the Cannabis Act, you need an organizational security plan. Under the ACMPR, there was no mention of an organizational security plan. Most consultants, including us, would give Health Canada information on how the security systems were installed, how they operate, the people that are going to manage them, the policy and procedures around the security systems. We even talk a little bit about GPP and air filtration and backup generators, the whole 9 yards, to give Health Canada the warm and fuzzies that the security of a site was ACMPR compliant and that they had enough people to operate it and that they really knew exactly how it was going to be operated to be compliant with the ACMPR and, of course, security best practices. Moving forward, under the Cannabis Act, there is no mention of security master plans. There is no mention of threat and risk assessments, which is another video. Go ahead and watch it. But they do mention an organizational security plan. That is a huge thing that's going to be ported forward under the Cannabis Act. You have to know exactly what your organizational security plan is going to look like. Do you nominate a director of security in it? Is there roles and responsibilities? Is it physical security? Do I tell Health Canada all my drawings and what happens in my facility? Do I let them know what happens if there's a robbery? There's a bunch of things that Health Canada wants to see. They don't articulate it. They don't necessarily tell you about it, but they definitely want to see an organizational security plan. Those are the top 10 things you need to be mindful of when moving forward to the Cannabis Act. Obviously, there's a lot of other little tiny areas, a lot of nuances, a lot of challenges with going from the ACMPR to the Cannabis Act. There's a lot of different things you need to consider. The Cannabis Act does sort of lay out a little bit more GPP than the ACMPR did. Doesn't mean it's not gray. I do talk about gray areas in another video. Point is, top 10 things you need to know. There are others. Reach out to your consultants. Reach out to your application consultants, your security consultants, your IT InfoSec people. That's a big hint about the organizational security plan. Reach out to your architects, whomever you may have on file. We need to get ahead of these 10 things I just mentioned, plus all the other little areas that may creep up, that are maybe gray right now, that Health Canada will realize pretty soon needs to be a certain way, and our interpretation of the ACMPR and Cannabis Act moving forward. Thanks for watching. Feel free to follow us. We have done a lot of informational videos. We answer a lot of client questions. But by all means, go ahead and ask your questions. Send us an email. We'll do our best to answer them. Follow us for other videos. Go ahead and watch other videos. Thanks for watching, and we'll see you soon.